countdown. It's a little early for New Year's. That countdown as we go live today with Marnie and Phil from Spring Law. Hey, you two.
Hello.
Oh, hello. How are you?
Good, good. Thanks for making time. For the folks that are early keener joiners, we're going to start in about 5 minutes officially, so you can just hang out, grab a glass of water, Pepsi, whatever, Dr. Pepper. I don't know what people are drinking these days, but yeah, we'll start at 12:05 on the dot. And yeah, what's your go-to beverage?
That's what I'm sharing. My Geez Louise fancy fancy drink for the webinar. I treated
Geez.
myself today to a pricey mocktail.
Besides coffee, a good soda water is what I'm all about.
Nice. So
Nice
you,
tie, Phil. We actually never commented on Phil's tie.
Oh,
Thanks
thank
for
you.
dressing up for today.
Thanks. I had to apologize to opposing counsel this morning for looking so formal, but I had a webinar that I had to sign on to after.
it's got the clip and everything too.
Yeah, that was a gift from one of my mentors from a previous life.
Nice, nice.
Yeah, it has a little. You can't see it. It has little scales of justice on
Okay,
it.
that's cool.
Previous life, was that in law or
No,
Phil's,
previous
Phil's
firm.
had
Yeah,
Phil's
previous
had
firm as a.
cool
Oh, sorry.
I just said you've had cool previous lives pre-law.
Yes, absolutely. I meant just from a previous firm when I was an articling student and became a lawyer for this one specifically. But yes, I've done a career shift or two in my day. So
Social work and a chef.
yes,
Like couple
yeah,
massive pivots, three of them in your
I
life.
remember
completely
the chef piece. Yeah,
completely normal transition into law practice. Okay.
you are an inspiration for all the chefs out there and
Hey,
social workers, really.
if they want to get out of the chef industry, there are mechanisms. You just have to go back to school and be stubborn and stay in school for a really long time.
Last night, so I like prep. I meal prep, not meal prep. I like food prep for the
Yeah,
dinner, beforehand. So like,
yeah,
I'm terrible in the kitchen. Like I know how to make a few things, but like when it comes to like, oh, you just like we're making this tonight. Like you can't
mhm,
rely on me to like
yeah,
figure it out. I need step by
yeah,
step instructions. So like halfway through getting all this stuff ready, I call my wife. I'm like, do you want me to like cut the carrots into coins or do you want the carrots in stick format for the soup? And she's like, oh my God. I'm like, you benefit from me in other ways. Like
yeah,
just
yeah,
accept this as a weakness. Let's move
yeah,
on. Are they
yes,
diced or sliced? Like just let me
yeah,
know.
yeah. I
I
need that.
in my household, I would like to be asked such precise questions. Maybe that's just my personality, but I'm going to tell that story tonight.
Yeah,
Coins, carrot
yeah.
sliced carrots like coins.
I,
This is
I
this is how you ask what needs to be done
yeah.
by Martin.
Yeah, it's exhausting, I imagine, to put up with me, but yeah.
And I do take that for granted because I'll cook dinner if it's not something that I'm like because if I want to cook, it takes me longer because I don't have all of the prepared stuff a restaurant would have,
Yeah.
right? To make a quick fancy dish. But if I'm just cooking something quickly, it's like 7 minutes later it's done, right? And I take it for granted that it takes people longer to like
Mm,
cook food
yeah.
than that, right? So yeah, it's
I would say triple the amount of time. Like my wife
easily,
can
yeah,
cook
easily,
up a meal in like a few seconds, and
yeah,
so
yeah.
it's interesting.
And we're opposite in the sense my wife does most of the cooking,
Mm.
right? So and she's a vegetarian, I'm not. So sometimes I cook some extra food for myself and all of this kind of stuff. So, but yeah, we're and she cooks great food, but it just takes her a little bit longer, which is totally normal, right? Because she's not me, and she's not trained in all of that stuff. So,
Yeah. I think we can get going here. So,
huh?
all right, folks, thanks for sticking around. We got a bunch of folks here today. We've got Marnie and Phil from Spring Law. We're going to be talking about essential employment contract compliance for HR leaders. I think this is a really cool topic, especially given to kind of to what you were mentioning, Phil, in the sense that like a lot of stuff can be taken for granted. And I think a lot of HR folks and just companies in general take for granted that they think their employment contracts are up to snuff. But oftentimes they are not, especially on the discovery side and you don't want to learn that at the like 11th hour. So I'm really excited about today's session. Yeah, over to you, Marnie and Phil. Only one quick note for everyone: we're going to be doing questions at the tail end of the presentation. If you got questions, just add them to the LinkedIn chat or the YouTube chat, and I'll keep an eye on them, and then we'll ask them at the tail end of the presentation. So yeah, over to you two.
Thank you. I'm kicking off the intro slide, but I just want to make a couple comments about Phil and I and our practice and why it's relevant to this presentation. Spring Law advises and represents both employees and employers. So this particular topic where we're talking about reviewing employment contracts, we're doing it we're drafting them for employers regularly, and we're reviewing them constantly if an employer needs to do terminations or reductions in force. But we also advise and represent employees, so we are looking at and analyzing these clauses from both perspectives, and we do this several times a week, and we have a chat going internally where we pop these clauses in, and we really take a hard look at them. So we see right from the drafting beginning of the employment relationship right down to the end where the stuff hits the fan and there's litigation, and we're constantly looking at these termination clauses because it's one of the key areas in employment law. So I just wanted to give that background about what Phil and I do in terms of and all spring law lawyers, and why I think it's especially relevant to this topic. So Phil, do you want to say anything there? Hello, etc.
Yeah, absolutely.
Sorry,
Thanks, everyone.
dominate.
Thanks, Marnie, for introducing us, and thanks everyone for being here and taking time out of your busy days to listen to us talk about things that we think are super cool. Right? Not everyone thinks they're super cool, but we definitely do. And to echo what Marnie said, yeah, we do this day in, day out, right? And Marnie's practice is majority, not to speak for her, is mostly employer side. Mine, by choice, is mostly employee side. So I'm day in, day out picking these clauses apart as part of suing employers, and right, but I also do work on the employer side as well to help that experience guide employers on how not to fall into the traps and find themselves on the other end of someone like me or another practitioner, right? So we do have that experience from both sides of the table that really do benefit our clients, and it allows us to really kind of, for lack of a better term, nerd out over these clauses quite often, right? And it's a cool part of our practice. It's a big yet small part of our practice, but it's definitely one of the most important ones. So I'm looking forward to presenting today. Thanks, everyone.
Okay, so thanks, Phil. So why this topic? So I work with a number of the people group folks, and some of you will know already how and why we approach this with, and we put such importance on it. I'm going to give you a couple of concrete examples in my next slide to demonstrate why this topic is important. But I'll start with a few bullets about that you'll all already know. Up to date and enforceable employment contracts, they create certainty on termination. So you've got a situation where you know you have to exit one or more employees, and if your contracts are up to date and compliant and enforceable, you pull them out, you read what the person's entitled to, the group is entitled to. You may or may not, depending on your level of experience or your how you work with your employment lawyer, you may or may not flip them to your lawyer and just get a gut check on what this is my approach. We have these clauses. I think I know what they need, and this is my draft termination letter. Here we go. That's the certainty that is so nice for HR professionals or anybody wearing an HR hat, whether that's your full role or not. It saves hassle, and just not having that certainty saves hassle where you're not sure what's going to happen on termination. I mean, I'm assuming it's one of the more stressful things for an HR professional to go through, terminating people. So it saves hassle and second guessing, and I'm talking about both for employers and employees. So employees, they'll recall what they signed, and they probably don't need to go get legal advice and spend money on that. They know what they agreed to, and it's done, and it's a nice, tidy exit in many cases. And on the employer side, one of the biggest benefits is that it reduces employer termination costs, just by having clauses that, in most cases, having clauses that have certainty, and often employers offer employment standards minimums or something slightly above, something that they know is within their budget when they're hiring employees. So they're not left with the uncertainty that is the common law, which Phil is going to get into later. Why this topic? I had this in the title of our slide. It's an easy HR win, and I get an unhealthy level of excitement buzz when HR professionals, I know they've rolled out some termination. I don't get a buzz out of employee terminations. That sounds very draconian. I get a buzz out of HR professionals doing their job well and knowing how exits are going to go and how they're going to be able to move people forward onto their next adventure, answer some questions, and it's done. And it's because the clauses in the term in the employment contract are certain. So that just rolls through. An employee exit is seamless, and most importantly, they can report back to their leadership team that this was conducted and there was no unknown costs and friction with the employee or demand letters from employers. It's an easy HR win to update your employment contracts and get that kind of certainty if you have to exit employees. Um, and my goal has always been, when I work with my HR friends and clients and so on, is to help them succeed in their role. This is a great way to do that. Save the company money, another great way to do that, and sleep better at night. Again, because terminating employees is the worst, and getting demand letters from employee side counsel is probably right up there after that in terms of not a fun thing in your job. So, this webinar is supposed to help with those three things. All right, Martin, Martin's driving today. We gave him something important to do. Next slide. Okay, so I'm going to give you some examples, recent examples, just on in a reduction in force I've had recently, or individual terminations, where we've rolled out the contracts, and I'm going to get into details about how to do that and how to assess whether you need to do this as HR professional at your company. But this is another concrete example of why it's important. So I helped a couple of employers recently with their reductions in force, and we had about a year ago, on the heels of this case law that Phil's going to talk about, we rolled out new contracts. So the reductions in force were all seamless. Nobody came back. Everybody understood what was happening. But there was one employee that had forgotten that they signed an updated contract, and a nasty demand letter came from an employee side lawyer claiming 6 months notice. The employee was a high earner, and there was a lot of potential exposure there. I got in touch with the employee side lawyer and said, I'm not sure if you have a copy of this contract. It was updated when the employer rolled them all out last year. They had a town hall. They explained the purpose of the edits or the updates to the contract. They received this in exchange for signing. It was all done transparently in a good communication. The employees all understood. The employee had simply forgotten to give that to their lawyer. So unfortunately, they incurred the cost of this review, but the employee's lawyer said this is an enforceable clause, and your claim for 6 month compensation, there's no legal basis for it. So that's an example. Like it was over and done with, and it just came up because they'd forgotten. But every other employee in that reduction in force, whether they got advice or just remembered that this was the deal in the nice, clean, clear termination clause, they understood what they were getting, or a huge number of employees, and it was all done seamlessly. So that was a great investment by the employer to have that certainty in this reduction in force. And the same example applies with individual terminations. It's the HR professionals I work with, we just haven't been seeing demand letters. We've been seeing cleaner exits where the employees, and again, less friction. They know what they're entitled to. They're receiving it. There's some dialogue around whatever they might be offering, outplacement, the ROE, or whatever. But it's not an acrimonious situation. So that's just to give some concrete examples of why this topic's important. And I've already referenced, when if you find you need to do these updates, you do them, and then you have these seamless, tidy exits. Let your leadership team know, because not everyone understands why these are tidy and the amount of money that's saved. I'm talking hundreds of thousands of dollars if we're talking about group terminations, and tens of thousands if you have some high income earners, in terms of creating certainty on what they would be entitled to, and limiting common law entitlements. Um, The other reason this is a great thing to do is that it can lead to further cleanup, a compliance audit, and further cleanup of things that require further compliance. So, or checkups, and examples can be urgent matters where you realize. And sorry, let me back up. When we go through the employment contract update, our workflow is that we take a look at the existing contract, we get a sense of the workplace and how they operate, and are they remote, are they hybrid, and how do they handle PTO or vacation, and get a sense of this is of course depending on the mandate of the employer, how much of a review do you want. But oftentimes we dissect what's going on in the workplace, and we identify potential areas that need addressing. And so over time, policies and practices often have non-compliant things in them that we identify and have a conversation about, because that's increasing potential liability costs over time if it's not fixed. Same with vacation policy and practices, and how vacation is paid. Is it paid on a total compensation and commissions and bonuses? This is a little known fact sometimes, and for years sometimes employers aren't handling that properly. So it ignites a conversation about the things that we know can become expensive if they're not addressed. So we start with the employment contract, but we flag other things that the employer may or may want to invest in fixing at the time. They control the mandate of what they want us to do, but we uncover things that busy employee HR professionals aren't necessarily aware of. Also, some non-urgent things come up that we will flag, something to take a look at. And I very much like, to let people know what is likely to rear its head down the road and what's probably fine to shelve. Calendar for future when you have time, or when there's a legal budget to review whatever policies are not necessarily the lightning rod type things that become expensive problems. So it leads to a further review of things that compliance cleanup that's very effective to do at the same time as an employment contract update. All right, I think I'm turning it over to Phil to get a little bit deeper into case law and the legal reasons behind this. Yes, here we go.
Yeah, so Marnie, thank you, Marnie. Really appreciate that. And Marnie alluded to some of this stuff in these cases that have been coming out, especially in the last couple of years. And every 5 to 10 years before the last couple of years, a case would come out and it would just demolish employment contracts across the board across Canada. That's a regular part of employment law. But the last 3 years have been especially bad for employers in these circumstances, because these cases just kept coming that would keep just demolishing termination clauses. And I'll explain a little bit more. I'm sure everyone potentially has or may not, but most people have heard of Waxdale. Big Bad Waxdale came a few years ago, and in short said that if your just cause termination provision, which we always our advice is usually you don't need them, but if you have one and it doesn't comply with the ESA, all termination provisions are invalid, and therefore the employee is entitled to common law notice, which Marnie has discussed can be months and months. Up to 24 months of notice for long-term employees, and if they're high earners, it could be a real problem for an employer, right? And this case, Waxdale, built upon previous cases that said there was a different standard for just cause than willful misconduct in Ontario at law, and therefore the termination provision needs to either mention the specific willful misconduct standard or be compliant by not removing all rights, even when they don't, any conduct doesn't amount to willful misconduct. So huge case. I would venture to say that when it came out, 80 to 90% of employment contracts in the country just became null and void as related to termination without cause. And then Defoe comes this year, which ramps that up even more to the point where a lot of employer side counsel are arguing that the courts have now started to say that they're going to assume that people are trying to breach the law. And I will explain to you what I mean by that. In Defoe, in this year, simple language in a termination provision that was entitled may terminate at any time and in sole discretion was deemed by the court to mean that sole discretion could mean in breach of the Human Rights Code, or in breach of the ESA, or in breach of various statutes. So it almost assumed that this language would allow them to try to breach some sort of statutory provision, right? Which is a little bit overreaching, But again, in January, I think January of this year, it came out and again decimated probably 70, 80, 90% of employment contracts in the country again, right? And later last year, another case called Henderson came out. And this case built on what all employment lawyers kind of knew up to this point was a general framework where the courts would be going, but it really solidified the idea that these void clauses or any mention of termination in the contract anywhere can void the termination provision itself. It does not need to be in the termination provision to void the termination provision. In Henderson specifically, there was simply a mention in the confidentiality clause way at the end of the contract that said, if you breach this clause, we can terminate you for just cause without notice. That's all it took. It voided the termination provision in the contract, entitled the employee to common law notice instead of ESA minimums. So Henderson was the state of the law in general, but it really got solidified after Henderson that termination provisions can be voided by language anywhere in the contract and potentially beyond. And Rahman came out and seemingly almost challenged Waxdale at the lower court level and said that in Rahman, just to give you some framework, there was an executive, highly intelligent, highly sophisticated individual who had counsel at the time and negotiated a termination provision with their employer. So actually had a hand in negotiating their own termination provision. Fast forward to termination, they found the termination provision to be void, but because they negotiated the provision, the lower court said he's not entitled to common law notice because he knew what he was signing, right? But then comes the Court of Appeal, says, well, that's not the law. The law is, if it's void, it's void. It doesn't matter as to intent. So then Rahman comes down and says all of these other cases, right, that say, well, Rahman came a little earlier, but the trilogy or the four cases together basically mean that termination language anywhere that's void voids the entire termination provision. Doesn't matter how smart or informed the employee is about the void termination provision. If it's void, it's void. And very simple language in a termination provision that implies a potential breach could breach the entire termination provision. So these cases in the last couple of years have just created this environment where the court's basically saying you have to look in the whole contract, including your probation clauses, resignation clauses, confidentiality clauses, and really assess, are you breaching a termination provision anywhere in your material, right? And I'll get into a little bit further what I mean by any material on the next slide. So then, just as a side note, right, employers, when they create their contracts now, they really need to be live to these cases, or hopefully speak to counsel and review their contracts and assess if they're compliant. And moving forward, also need to assess whether they want more general language if they have employees Canada-wide, or more specific languages per province as well. So that's important. Like we have some templates that use the word ESL, Employment Standards Legislation, versus Employment Standards Act, because we know some of our clients are using these templates across provincial boundaries, right? And that's that could be a whole topic in itself. Yeah.
Can we just clarify that our view is this is largely an Ontario problem, because these are Ontario cases.
The Waxdale problem specifically, yes, is my apologies. So thank you, Marnie, for that. The Waxdale problem specifically is an Ontario problem. Absolutely. The other cases, Defoe, Henderson, and Rahman, have more application in Canada-wide, but Waxdale's application of anywhere could potentially invalidate the without cause provision is potentially applicable, but the differentiating standard of of willful misconduct in Ontario and just cause is so far only applicable to Ontario because other legislations don't have that distinction. And that's a very fair point, Marnie, for sure.
Yeah, and I think that what we do is because Ontario tends to be the Ontario case law tends to be and legislation tends to be viewed as at the forefront, and a lot of provinces follow Ontario. We use that as our baseline. So for our interprovincial employers with employees in various common law provinces, we're not talking about Quebec right now, different legal system, but with employees in different provinces, we generally draft for an Ontario-centric contract, but we want to know where other employees are based, and then we do a check. I think Phil, I think you're going to chat about this a little bit more, but I just want to flag that's we approach it Ontario. It doesn't matter if you have employees in other provinces. We
Yeah,
try to have the same contract. If
yeah,
the client wants, we can
yeah,
do, but it is this
yeah,
Waxtail
yeah,
piece started in Ontario, and we're most
yeah,
cautious about Ontario
yeah.
contracts, and it's the most expensive problem for employee and Ontario employers.
Exactly. And
Okay.
we use the higher standard in our contracts to permeate all, just because in the future, it's only going to get stricter, most likely. The chances of the courts getting less strict on employment contracts is unlikely to happen. So thank you for that. And we'll go on to the next slide. So, what are the courts saying to employers in simple terms with all of these cases? Basically, they're saying you have to look at everything you give the employee, right? That includes the employment contract, that includes policies, that includes confidentiality, non-solicitation, if it's a CEO or a sale of business, non-competition clauses, which still have some application, right? Conflict of interest policies everywhere. You have handbooks, right? If it's incorporated into the contract, you got to look at the handbook. Is your handbook 80 pages long? Yeah, well, it could be in there, right? There could be something in there breaching the ESA and invalidating the termination provision. And on that point specifically, I can share an experience I had with this, that I had a file approximately almost a year ago. Wow, I was about to say 6 months, but it was almost a year ago now, that settled on the trial doorsteps because when the action was initiated, there was a termination provision attached in a policy to the contract, and it was the plaintiff's position, we were on for the plaintiff when the case first came out, that the policy was not validly attached to the contract, and therefore it didn't apply. A few years go by, because that's how slow our justice system is, and the matter is about to go to trial, but it's about to go to trial after Henderson comes out. Remember, Henderson is the case that says you have to look everywhere. And it was the employer's position that the policy was validly attached to the contract. So then, as on for the plaintiff, we switched our tune. We said, yeah, the policy is attached to the contract, actually, and it has a void termination provision. Therefore, the case is in our favor easily. And we sent the cases. We didn't even send our position to opposing counsel. We just sent the cases, and we had an offer to settle a week later because Henderson comes out and creates this new environment where, our client got somewhat lucky in that sense. We had other positions, but got lucky that this Henderson case came out, and a policy that was or was not attached to the contract had an unenforceable termination provision, and therefore entitled to common law notice, and a huge exposure for the employer was there. So that yeah.
Can I just jump in with another example that's related, but it's a bit closer to the termination provision? You're talking about like ancillary related
Yeah,
documents.
yeah,
This one, another or a couple of examples we can give is when we say look at all termination related provisions, not just the termination clause. Another example is a resignation clause often appears right before a termination. The termination clause, and if you have one, for example, that says you can give X amount, we require X amount of resignation notice, but we can decide, to determine your last day of actual employment on this date, and you'll be paid until your last day of work, which that's in a lot of contracts that
yeah,
breaches the ESA, and that would strike out your whole otherwise enforceable
yeah,
termination clause that says they
yeah,
don't get common law notice. So that's
yeah,
one example. Probationary periods that don't talk about 3 months less a day, that say 3 months is your probationary period. We see lots of arguments that violates the ESA, and it does, and therefore the whole clause is struck. So it's things like that where this reach is wide. Like it's like someone
yeah,
referred to this as a game of whack-a-mole. Like you have to
yeah,
keep fixing fixing potential breaches and
Mhm.
reading a contract for potential breaches and plugging those holes until the next
Yeah.
case comes up.
Yeah,
So,
exactly. And it's actually quite relatable to my experience because the case that I was arguing was a resignation notice piece with an attached policy that had to do with resignation notice that breached the termination provision. So Henderson was like directly applicable and it was game over for the employer. So I think I'm handing off to you, Marnie, for the next slides. So
okay.
it's all you.
All right. So this assessment starts where you're sitting there thinking, I may or may not have out of date contracts. Maybe you're new in the role, or maybe you've just been using the contracts and nothing has arisen and you haven't had any issues. So that's great news. But I think as we're saying, it's worthwhile exercise to find out what cleanups you might need. So talking about new hires, then you're going to, it's a more straightforward exercise, just cleaning up your templates for when you hire new folks. I'm going to get to existing employees in a second, which is more complicated. But your first steps would be to pull out your template employment contract. You probably have a few versions depending on the level of employee, but the one you use most is your starting point. What was the date of its most recent legal review? When was it last updated? By whom was it updated? Ideally, I think and I've been doing this a long time, and I wouldn't have said this throughout my career, but I think at this point you should have an employment lawyer looking at the clause because of, all the complicated case law that Phil was just talking about. My eyes glazed over. No offense, Phil, you're very interesting, but it's like your head starts to swim with what the courts are saying. So I think an employment lawyer should be revising and reviewing the clauses. So look at who last reviewed it, even if it was last year. If it wasn't someone who's up to date in the case law, then maybe it is worth having it reviewed again. You want to look at what amendments or other documents might be kicking around, like a one-page amendment that says these terms apply to your employment, but so does the original contract that you signed. Those are enforceable terms, and you should have all of that gathered for your review, so you understand what the terms and conditions of employment are. Um, and then you're going to look at your policies and handbooks, as Phil's been talking about, to see what else might need review, cleanup. And Phil's going to give some tips on what kind of phrases to look for too, which will be really handy. That's the slide 8 that we're going to flag for you. And then if you find you have these updates and say your vacation policy or overtime policy practices, look at, plan ahead and decide when a good time to do this review of your templates is. And it's quite seamless and it dovetails well to do it all at once, whether it's at the end of the year, beginning of the year, June 1st, whatever it is, timing wise, in the workplace where it might cause, like, ruffle the least amount of feathers. Try to do these updates at the same time. If you only have budget and time to do the contract and any termination related provisions, then just do that. But it is worthwhile looking at other things. Then you have your whole package for your onboarding. It's all up to date, ESL compliant, and there you go. Your new hires get all these shiny new documents. Now I'm going to talk about existing employees, which again is a little trickier. So let's take a look at the next slide. Part of the analysis for existing employees, um, rolling out, it's more careful strategic analysis that requires a review of the full context. So you're going to start with the individual contracts for the employees who have old out of date contracts. And our workflow for this is actually quite similar to a reduction in force. We have a spreadsheet where we look at and hyperlink the contracts. We understand what the termination provisions say. We know what the potential risk is if the clauses don't hold up. How old are these employees? How reemployable are they? What's their comp? How long, length of service, all the common law or Bardol factors, if you're aware of the case law that drives common law entitlements. We look at all of that, and we put that into a spreadsheet that is similar to a reduction in force exercise, so we can assess risk and potential costs. And then we do we give the employer a risk analysis, and we based on the clauses. If you needed to terminate, this is the exposure. So essentially, we look at the termination clause and say, like, how bad is it? And then we talk to HR about, yeah, this needs to be reviewed, it needs to be revised and updated. Let's figure out a way to do it. Or, the risk is pretty minimal. You may just want to sit tight and not and just understand that there are going to be increased termination costs if and when you get to that point. But often, not poking the bear, for lack of a better phrase, is better, and not ruffling, because employees do get, if it's not handled perfectly, appropriately, with good communication, they wonder why this is happening sometimes, and it can impact morale. We're going to talk more about how to prevent that and do it in a way that's smooth and where employees feel like they've been treated fairly and so on. We'll get to that in a second. But yeah, so this starts with a review of your workforce. What contracts do they have? Spreadsheet it, get a good handle of on what we're looking at and what contracts do they have, and includes amendments and everything else. Um, then you're going to do your strategic review of the impact on the employees. So how flawed is their, or how out of date is their termination clause, and what would this look like if we terminated? If and when you decide, yes, these need to be updated, then the next stage of the analysis is, when should it be done? And it needs to be done when there's consideration, which is the fancy legal word for something of value, meaning what can you give these employees in exchange for giving them an updated, compliant contract? Because this means that they have worse terms in the updated contract, or more adverse terms. So for the new updated contract to be enforceable, they need to be giving something of value in exchange, or at the time of termination or any other time the employer tries to rely on the contract. If they get legal advice, their employee side counsel will rightly say this contract is not worth the paper or virtual paper it is written on, because you didn't get sufficient consideration. So the next conversation we have is, are there bonuses coming up, salary increases, things that would normally be happening anyway, something additional for the employee? Is there a new health spending account, or perhaps more vacation days, or there are no rules about what consideration, what is valid. So employers can get creative with it, and the more you're able to provide as an employer, the more enforceable, or the more enforceable the contract will be. But it's a fairly low bar for what consideration is valid. But more importantly, the less impact it will have on morale. So the ones I've worked with employers on, it's worked very well. They did it at a time when they could roll out 2 or 3 more bells and whistles that were important to the employees. Sometimes they weren't necessarily that expensive, but employees were happy about it, and they communicated it well, and they explained that. This contract update is coming on the heels of some new case law in Ontario, and whether you say we're doing a compliance audit, and we're updating our policies and documents, and that's why you're getting this new contract, then it's more smooth for the workforce, for the employees. They understand what's happening. Um, that's the careful communication I have in a bullet, is that's what that's all about. So whether you have a town hall, or you carefully prepare your talking points and you put them into an email, a meeting with employees to explain this is, I find, the way that works best. Timing is important too. So depending on what you're able to provide as consideration, you could tie it into a holiday bonus. Again, ideally something that's above and beyond they would receive anyway. And maybe it's end of year, maybe it's Jan 1, but all of those, those are specific to the workplace, but all require consideration. And when we do the strategic plan, there's lots of things we think about based on what we've seen not go well, or work really well. And if done properly, and with planning ahead, these can be very effective and smooth. Um, if you find, again, that the clauses are not that up to date, not that out of date, or not that flawed, like potential minor issues, that's what we would assess. How bad is the clause? Sometimes doing nothing is best. And again, just understand that risk. If you identify some potential problems, calendar it, review it at a time when you're able to provide consideration or something of value, and that is the time to do it. That's the time to roll out the updated contracts. And if employees decide they don't want to accept what you're offering, that's a different conversation. It could be another few sides of this webinar. But the employer can say, this is a new offer of employment, and we recommend providing notice of when that would kick in, and therefore you have notice of the changes to the contract. And also, I've done a few where we provide consideration as well. So you've checked 2 boxes from a legal compliance standpoint. You're providing consideration in exchange for the new terms offered, and notice. So the person, in theory, has time to adjust to what's being offered and go look for another job if they really don't like the new terms. So if ever challenged, that contract is again 2 great clear boxes checked in terms of how this has been rolled out. If you do roll out updated contracts and employees sign them back, remind them to save those contracts, because that will avoid the scenario I've referred to at the beginning of this, where this poor employee forgot they'd signed this updated contract, spent money on legal advice, went down that path, and then we provided the updated one, and then it was the end of story at that point. So remind them that these are your new contracts, file them away. This is what governs the terms of employment from this point forward, and that will save them the hassle and cost of getting legal advice about their termination. Over to you, Phil.
Thanks, Marnie. It's really helpful to hear go from point A to point B and how to most help the client, right? Because you're right. We tell them these things because we take it for granted that this is our everyday language, right? and many of our clients have exposure to it, but they don't live it like we do. So thank you. Yeah. So just to kind of follow up and to reiterate, review your policies, right? Ensure no ESA breaches are buried within them, right? And that's all policies. Hopefully have some guidance if your force is large enough to require an employment lawyer, but even not, have them review it in a fashion that works with your industry and works with your specific workplace, right? And you can use search terms, right? So you can do some of the review yourself. You can come to the employer after and say, I've used some of these search terms. I've reviewed all of our policies. I have, these 10 concerns, right? And that can save yourself a lot of time and a lot of hassle, right? And a lot of the lawyer's time too. And we love it when clients come prepared to us and have a whole bunch of concerns listed, and we could just answer them really quickly, A through Z. And of course, we'll go through and we'll look at the documents a little bit just in case, and look for similar terminology or terminology that may have been more recently discussed by the courts as problematic, and just do an overview to make sure that compliance is ensured. So, some of these search terms are for cause, with cause, immediate termination, without notice, without pay, for any reason, at any time, sole discretion. One that's not up here is just, it says without notice or no notice. Sometimes I search for just notice or just discretion, because sometimes it's prefaced with a different word than sole, right? and so we want to go through and a lot of our jobs, I don't know if Marnie will admit it, but I'll admit it openly. Control F is a big part of my job, right? and helping people to understand what they're looking for is part of that, right? So, subject to very limited circumstances, this is important. Saving provisions don't save unenforceable clauses, right? We always have them in our contracts in case a new court decision comes out and overturns that approach. But the current approach is that the clause at the end of a contract that says anything breaching the ESA will be removed and the clause will remain enforceable notwithstanding the breach. That's long been determined by the courts as not valid approach. There are very limited circumstances where that's not the case. And I won't discuss them here because they're too nuanced to apply, and we just treat it as it never applies, because that's the safest approach. And so, because we've had clients come before, it's like, well, I have the savings provisions in my contract that says no breach, that if there is a breach, it's removed, and therefore there is no breach, right? But unfortunately in Canada, except for a little bit of Alberta stuff, which I won't even bother with, doesn't do redlining or blue lining or removing of unenforceable provisions, right? That's a very United States of America phenomenon, where contracts in the employment sector will actually be redlined and unenforceable provisions will be removed if there are savings provisions. So that's just one piece we wanted to throw in there when doing search terms and stuff, is that, if you find a provision that looks like it's the saving grace, it may not be. So.
Phil, can I add something to that on the Control F exercise? So this is just to be clear. We've somewhere in this presentation we've said it's non-exhaustive list, and by that we mean there are other things that weave their way in that are kind of more this legal analysis based on the case log. We have pretty healthy debates in our weekly file reviews about whether something's problematic or not. So this is where, do your Control F, highlight the terms for your employment lawyer and say, I understand these can be problematic. Here's what we have, but let them do their job. and do the analysis to figure out whether it's likely to be determined to be invalid or not. So it's
Yeah.
just a starting point to see whether you need to invest or not. So if you had a recently updated contract with none of this, it might be safe to say we're good. So this is just a tool to help as a starting point. I want to make one other comment on the sole discretion. One of our things that we do is because courts have been critical of these clauses that say employers can do everything they want in their sole discretion, because that can lead to breaches of occupational health and safety legislation, or human rights legislation, and so on. So one of the things we do is we tone that language down when it's not necessary. So sometimes there's this really one-sided language. I used to draft it, admittedly, way back when, but like the employer can do this and their unilateral sole discretion, whatever the heck they want, whenever they want. Like, just tone it down and just have what you need, and then it's just a more balanced contract. And so you can look for that kind of thing too. Again, like, leave it to your employment lawyer to pull it all together and make sure it's consistent. But that's, as a theme, one of the things that we've been doing with contract reviews and updates too, driven by this case law.
Thanks, Marnie. Is the next slide yours, or are we sharing the next one? I think we're sharing the last one, right? Or if it's not the last one, that's you. You're on deck again.
Yeah, this is just to kind of pull together some of the tips that we've talked about. This could be your starting point if you want to figure out whether you need to review or not. So your employment contract compliance assessment initial steps would be, again, pull out the documents, not just the contract, but the policies and any amendments. Look at the history of who updated them and when. Check for the terms listed on slide 8. It's non-exhaustive, but it's a good starting point. And then in your documents and policies, look for that termination related language, like stuff that says, you can do terminate for cause and all of that, again, tied into the slide 8 terms. But even, there might be things that are not listed in slide 8 that just have, talk about when someone can be exited and for what reasons. That could be improper. So, when you're doing your review and flagging things for your employment lawyer, look for that. And potential ESL breaches, or Employment Standards Act breaches, Employment Standards Code if you're in Alberta. Look for potential breaches, and those are the things like the resignation provision that says we can cut you off at this point if we decide to exit you, or the probationary clause, or another one is vacation pay. Vacation pay carryover. If it says it's a use it or you lose it policy, you can't carry over at all. That actually breaches the ESA, because employees are always entitled to their ESA minimum vacation entitlements. So a use it or lose it policy is a breach. We haven't seen that tied to we haven't seen that lead to striking down of termination clauses yet, but it's a good practice. Admit that could potentially happen. It's just a good practice to take anything out that breaches the ESA, because there are other decisions where courts have awarded damages against employers who don't comply with the ESA, or ESL, we're calling it. Employment standards legislation we're using as a broad term to refer to all provincial employment standards legislation. So look for potential breaches. You'll see at the end of this slide we put a link to the Employment Ontario version of the Employment Standards Interpretation Manual, which is a lovely resource that I highly recommend you bookmark. And most provinces have such a handy resource. So if you're not sure if something breaches the employment standards or ESA in Ontario, that's a good place to start that guide. And it's in the next slide. So that's what you're doing in terms of reviewing your policies and plan docs. And you're looking at the number of employees who have outdated contracts, if any, and then you're going to look at do a cost assessment, and what would this look like to roll it out? Is it worth the hassle? Is it going to impact morale? Is there a way to do this without just it being messy, basically? And then once you've decided what you're going to do, you consult with your employment lawyer and talk about how to do it, what level of consideration, how you're going to communicate this to employees, and just your talking points, and just make sure it's all super planned, and it will likely go very smoothly. And then our wrap up slide. Martin, if you can just take us to our last slide, and then we'll take some questions if you have. Just to reiterate, what you've learned today can certainly help justify your legal spend to your leadership team. We know that many companies have tight budgets, especially nowadays, and it's hard to figure out what to spend and when. And so this one would be, once you if you do your cleanup and you have these wins and these seamless exits and you save on termination costs, point that out and report back to the team about that, again, because it's not always obvious. And updating those contracts will create that predictability and reduce the termination costs and hassle, and just help you sleep better at night, because you don't have the messy parts of your job will be easier. And then Phil, you want to talk about our resources?
Yeah, and I think you and I chatted about this yesterday too. It, like, for HR professionals, spotting this kind of stuff and solving it, that makes you look great, right? Right? Like you can really shine to the people that hold the purse strings and just run the company if you save them a ton in an upcoming reduction in force or something like that, and plan it and execute it in a way that saves the company a lot of money. So,
and even you can go and say, we did an analysis and we're good. Make sure they know you did the analysis and actually don't need anything done.
Exactly. And part of that, is, dovetails well into this. We stay current. Lots of blogs, newsletters, many great ones. We come out with one weekly, right? If not more often, right? On all of this kind of stuff. Usually any big case that comes out, it's going to be blogged on within a day or two max, right? And bookmark some of those key resources. Marnie talked about one of the best ones. We use it for employer side counsel, for compliance counsel. The policy interpretation manual is excellent. It provides examples of fact situations in difficult provisions that are hard to read, like vacation pay is the bane of everyone's existence, whether you're an employment lawyer or an HR professional. Nobody knows how it works properly, especially when it's implemented within a maternity leave or a parental leave, right? All of these kinds of things, and it gets really messy. And the policy interpretation manual really helps with that. At the very minimum, as a first place to look, if you want to chat with an employer from a more informed place, so you're speaking apples to apples, right? When you have your first meeting. So definitely stay up to date on all of that stuff, because even beyond us, every law firm out there that's great puts out a lot of really good material that helps keep you informed, and we do for sure. So that's it for me. Marnie, I don't know if you have anything else. I just want to thank everyone for having us today, and I hope it was informative and not too scary, and we're always happy to chat more. And if there are any questions, just throw them in.
Yeah, thank you. Over to you, Martin. Thanks to everyone for joining us.
No, thanks so much. I wrote down. We've still got time, so I'm gonna make the most of this 9 minutes. I've got 9 minutes of questions. I'm sure if you've got questions, you've been listening in. We've got a really healthy group of folks that have been watching. Thank you very much. So if you've got questions, so first one's coming in from Akriti. She said, can you share the link for the ESA interpretation? That is going to be in the presentation, and they shared it. So if you are a member of the People group, we'll share that back out in the legal channel. If you're not a member, you should probably join just regardless, but we'll put a place. I'll put that in the link in the description as well. From that perspective, not often do I get to answer questions, so I got excited and I just went ahead and answered that one for you. For folks wanting to get in touch with you, this slide is obviously the best slide to go with in terms of folks reaching out if they've got more specific questions. I would say one thing I wanted to get clear for myself, because I was like jaw dropping while you were saying, so like if something in the employee handbook contradicts or violates the ESA, does that make the employment contract like null and void? Am I understanding that correctly?
So I'm happy to field that, Marnie, unless you want to touch it. Specifically as it relates to the termination provision is the most important aspect here, right? Because something in the policy or the handbook can run counter to another part of the employment contract currently as the law is. And especially if you have a provision in your contract that says the contract, if there's any ambiguity with other policies, holds force and is the ultimate determinant of the right, then in those circumstances, non-termination provisions can usually be saved by the contract as paramount if there's something confusing with the policy. However, if in the policy something related to termination voids runs counter to the ESA, it very well currently, as the law stands, could void the termination provision, which really at the end of the day is almost the most important part of the contract most of the time. Not all of the time, but most of the time that's the most important aspect. And importantly, if it doesn't overtly run counter to the ESA, but just causes confusion and ambiguity, there is an area of the law that says if it creates ambiguity, that ambiguity is interpreted against the drafter, aka the employer, which then null and voids the termination provision as well, right? So to answer your question in short, yes, as related to the termination provision, other aspects of the contract could still be saved, but often they're not at play that costs the employer anything, right? So if they're saved, well, does it really matter, right? It does in the circumstances if, like, let's say, just for discussion or context, if you have a countersuit against a fiduciary employee that breached a confidentiality provision, right? And there was a policy term that contradicted the contract term, then it's important, right, that the contract term holds if it's stricter, right? But as it stands for termination provisions, it'll most likely void them if it's in the policy and breaches the ESA for sure.
I have an example that I'm thinking of that happened is it was a conflict of interest policy that had all kinds of things that the employee is not supposed to do, and I think it was like accept expensive gifts as in part of their role. And then it said in violation of the above or of this conflict of interest policy will lead to immediate termination for cause. So that violates that per Waxdale. That's a problem. And what happens is we get letters from employee side lawyers, and this is this whack-a-mole thing where they look around at all the documents and say, right there, that's a Waxdale problem. That was buried in your conflict of interest policy in your employee manual. It directly relates to termination for cause, which is an impugned provision. We all know that. That's clear. Your clause that you just updated that you think is so great is now void. So we will say, and there's some case law that gives us some arguments back to say, well, not so fast. Here's how we answer that. But what happens is there's legal fees on both sides. This is this cost and hassle we're talking about. And there, it gives them an argument, the employee side lawyers. And like per week, we have 3-4 demand letters coming in with new novel arguments about like the next whack-a-mole thing you got to deal with. Like, no, that's not what the case law says, or that, but it invites a conversation that doesn't need to happen if you strip out all of this for cause language from this buried conflict of interest policy buried on page 50 of your manual, or your whatever non-compete provision that's supposed to apply to only executives. It has some weird thing in it about termination for cause. It's that. So long-winded way of saying, yeah, you can have stuff buried away that can cause your clauses to fail. It doesn't happen a ton, but like if you're going to do the compliance audit, you might as well look through everything.
Yeah, no, very, very helpful. Thank you. So I've never done this in the history of people group virtual sessions, but we've got a few extra questions coming in here and I don't want to leave folks hanging. Do either of you have a few minutes to go over, or?
Yeah, sure.
I know you gotta
I have like 10 minutes I can spare, but besides that I just have a family appointment to get to, so it's not even work. But do you want me to field the first one? What are your thoughts about employers including language in the contract that waives employee rights to common law? That one's pretty simple. Most of our contracts have overt language that says, because of above, aka the very valid enforceable ESA termination provision, you waive any right to common law notice. And sometimes it's in exchange for additional notice above and beyond ESA, but it's in there. But just as a substantive answer, it is not the determinant on what doesn't entitle them to the common law notice, right? That waiver, it's helpful, but it is not what limits them to not be entitled to common law notice. What limits them is the ESA limitation termination provision, the without cause provision that limits them to ESA minimums. We add that waiver of common law just as an extra, just to be very clear, but it is not the guiding clause that enforces the termination, the lack of common law notice.
Gotcha.
Just to add to that, I think a very important principle is that the employee needs to understand what they're signing. So I always add that in because
Mhm.
people generally, well, they can Google it, or they generally understand common law is like that's the better entitlement. So you need to, I think it's very important to say, in addition to what Phil said, all of that ESA limiting language, but I think it's important to say you will not be entitled to common law notice. They need to know that, and if they don't understand it, then they can go in and get advice and understand what it means. But I do think it's important to have in there, in addition to the other components that Phil talked about. So it's a great question. Hi, Kat. Great question.
Awesome. No, thank you. We got two more questions. I don't know if they're easy, and we'll
The one from Akriti. I apologize if that's not how you answer your name. This one is too large of a question to answer on this forum, but I can definitely say that it's a conversation you need to have with employment counsel if you can, because these types of termination situations trigger the Human Rights Code, and no matter what you put in your contract, any such termination or even discussion of such a termination needs to be very carefully handled with white gloves, with the guidance of someone who practices employment law well. So.
And in terms of what you include in your contract, you should
Yeah.
never reference anything like that. But what's important is say we accommodate employees who require
Yes,
accommodation, and we comply with Human Rights
100%.
Code and all of that. So
And
yeah, it's a detailed
exactly.
analysis.
And there needs and it just triggers it triggers more of a conversation too about, do you have your anti-discrimination, anti-violence in the workplace policies? Are they up to date? Are they valid? Because that helps protect you, not against termination so much, but against allegations that you're not even an employer that takes it kind of seriously in that sense. So,
This is a good question, and it's a
yeah,
scenario that does come up. Employees
quite
do
often.
cite issues, and they may be very valid things that the employee is going through, and it does
Yeah,
require a full look at the employment history and performance
yeah.
reviews and things like that. So it is one of the
It's
more
a
complicated areas.
it's a very valid question, and it's the subject of our weekly file meeting quite often. So.
not a question, not a scenario to just sort of like put your finger in the wind and
Yeah.
see, to figure it out yourself kind of deal. Like that's one to like
Yeah.
to saddle up and call the folks at Spring
Yeah.
Law.
And expect that you probably still get a letter from they'll get
Yeah.
counsel, and you probably still get a letter from lawyer, which is fine, and that happens
Yeah.
often. It doesn't mean that
Yeah.
you didn't handle it appropriately.
Yeah.
Gotcha.
Absolutely.
One last question here, Phil, and Marnie. Thank you both for going over time here. It's from Ariana. So, making handbook policy updates for 2025, sick leave policy update for the new year, reduction. What are the consequences for not providing enough notice?
Hi Ari, always nice to see you. Great question. Employee, it's more of I think what's important with these is a gut check. Like, how is this going to be perceived by the employees? And you do have to look at how long term are the people, how relevant is this change to them, and it there's no exact science to the right amount of notice. Like if you're making a change that's a material change, or one a change that's a fundament can be considered a fundamental change. If you don't give enough notice, that's a potential constructive dismissal. But something that is kind of non-material and like sick days, is it a minor change? Is it something that's really going to impact people? The more they'll care about it, the more notice you should give, and you should plan on that note, on plan ahead if you can, and give as much as you can. Like 6 months would be great, 3 months probably minimum. But really, what legally is, it depends on the termination provision in their contract. And I know we're not terminating here, but the termination provision determines how much notice you have to give in also situations like this when you're making a fundamental change. And
Mm,
it's kind of a
Mm-hmm.
weird, but that's your starting point. That's the notice that you need to provide. So if everybody has valid, up to date contracts, the notice they're entitled to is valid, up to date contracts that limit to ESA. The
Mm-hmm.
notice you give is ESA notice. So it's a
Mm-hmm.
maximum of 8 weeks. So we should have included that in there. We should have said this
Yep.
helps
Yeah.
with changes to other fundamental terms of
Yeah.
employment. You made us think of that,
Yeah.
Ari. That's
Yeah.
another reason to get your contracts in line, because then you can make other changes, and your
Yeah.
notice period for those changes is ESA.
Yeah.
mhm.
No, that's a very fair point. I just want to add, because I just did this, I updated a contract for a good client of ours. And in the fundamental changes provision, I directly quote the termination clause in the sense that you will be entitled to the notice as per the clause 19 or whatever it is, right, in your termination provision. And there's some really cool case law out there that helps save employers even more money, in the sense that if you have that, and employers rarely pull the trigger because it's a scary constructive dismissal claim potentially, as Marnie said. But if you have that clause and you want to input a new termination clause change into the contract, there's case law out there that says as long as you give the ESA notice that this termination clause is coming, change is coming, then that's potentially a valid approach, right? Subject that it's not employment advice, but there are some really cool cases that can protect employers, especially large scale employers that are making these changes regularly. And it affects many people. So
On a practical level, give
yeah.
as much notice as you can. And if
Yeah,
anybody pushes back and says, "Oh,
absolutely.
how can you really do this?"
Absolutely.
You can
Yeah,
say, "We can actually do this and only give you this notice, but we've given you 6 months or 3 months or whatever." So that's just the decent thing to do for employees if you
for
can.
sure.
And
Yeah,
you can let them know you've gone above and beyond.
Kind
yeah,
of going back to that consideration piece, right? That's one part of it is time.
yeah, exactly. If that's where employers are often stuck. It's like, do I have to give consideration or do I have time? And most of the time they don't have time to give such notice. So we have to figure out a way to roll out contracts or provisions with consideration and time in it a way, like Marnie said, that doesn't affect morale. Like, is there a rebranding coming up that we can use? Is there a promotion that we can use? Right? Is there some sort of event in the company's growth that we can use as an excuse for new contracts or new rolls out of policies? So that's a conversation we have clients all the time.
Makes sense. Well, no, thank you so much, both of you, Marnie, Phil. This was great, super informative as always. Hope to do one again in 2025. And for all the folks listening and watching, yeah, check out springlaw.ca if you want to get in touch with them. That's the easiest way. Or in Slack, they're in the Ask Legal channel on a regular basis, helping folks understand some of their questions there. So thank you so much for supporting the community. Thank you so much for today.
It's a great community. Thanks for having us.
Thanks for having us.
Take care.
All the best. Take care.